It's a beautiful day here in Amsterdam, and I am delighted to welcome you to a new episode of the Computational Antitrust podcast. My name is Thibaut Schrepel. I am a faculty affiliate at Stanford University Codex Center, an associate professor of law at the VU Amsterdam, and the creator of the Computational Antitrust project, which explores how legal informatics can benefit antitrust law. The project brings together over 65 competition agencies and about 50 academics on the advisory board. Every month or so, we publish an academic article on the subject of computational antitrust. You can find all of these publications at computationalantitrust.com. Today, I am delighted to receive Mariateresa Maggiolino, who is a full professor of competition law at Bocconi University. Mariateresa wrote a paper for us entitled Antitrust Concepts and Artificial Intelligence, the Case of Plausibility. So first of all, thank you very much for writing such a great paper and coming on a podcast. How are you and where are you?
Oh, thank you, Thibaut. I'm fine. I am in Milan. I'm very happy to join this project and the broadcast because I'm happy to share with you and with the audience our ideas about computation and antitrust.
Yeah, you actually joined us in last year's conference. So some very careful listeners may have a taste already of our discussion today, but there is more now. So I'm very happy that we have the time to dive into your publication. And I guess a way of starting would be me asking if you could give us the key findings of the paper in just 1 or maximum 2 minutes for someone in a rush.
Yeah, I will be even shorter because my paper begins with 2 key points. First, AI has an incredible computational power. And second, natural language processing software is among the most advanced forms of AI. Therefore, it makes sense for me to use AI to analyze text, such as court rulings and decisions from antitrust authorities. And this is what I propose to do in my paper, to analyze these texts to get answers from them. And obviously, to obtain meaningful insights from AI, we need to ask the right questions. And so in my paper, what I did is to explore how AI could be used to answer the question, what is plausible within antitrust law? What do we mean with the concept of plausibility when it comes to antitrust law?
Yeah, and you do explain how it's related to probability. So if someone is interested in the difference between the two, it's in the paper. What I thought we'll be doing is dividing the conversation in 2 different parts. I want to talk about what's possible today with computational tools and the relationship with computational antitrust and plausibility. And then maybe we'll do, kind of the crystal ball guessing of what's coming tomorrow, but more on that later. If we focus on today, can you first explain how the concept of plausibility manifests in antitrust? Or I guess a different way of asking is, how important is that concept in making antitrust work and a field that you can practice and get to certain answers to?
Okay, well, the concept of plausibility is crucial in antitrust law in 2 main ways. First, it has a substantive significance. For instance, in the EU, it helps identifying potential competitors because they are defined as companies that could plausibly enter the market.
Yeah.
And second, and even more importantly, the concept of plausibility plays a vital role on the evidentiary side. Consider that in the US, it defines the standard of pleading established by the Supreme Court in Tumbly, which requires that a complaint demonstrate a plausible right to relief to proceed.
Yeah. So it is central in making it workable because indeed it's hard. And if you practiced, you will be aware of that, to get to perfect answers where you know for a fact that, in a almost as we could do in physics to say that's the definite answer. So you need this idea of plausibility to say, well, that's the best we can do and that's good enough. And so let's move on.
Yeah, you needed to filter out what would not succeed in any way. Whatever is the kind of evidence you can prefer.
Exactly.
And you needed also to discriminate, for example, when it comes to potential competitors, speculative ideas about possible competition from concrete possible ideas of competition.
Yeah. And where it would get tricky, I guess, is if you were to ask someone 3 years ago, is it plausible that using transformer technology you can compete with Google search? And maybe at the time you would say, well, it's not. And today you would say that it is because it's ChatGPT. But we'll come back to that in a minute. For now, I would like to focus on how to make it work, or to put it differently, how can we use computational tools in order to explore that concept of plausibility and indeed reach those conclusions that we need in antitrust. One idea you mentioned in the paper that I really much enjoyed is the idea of using natural language processing, NLP, to cluster cases where plausibility has played an important role. Could you please explain how, as a profession, whether academics or practicing lawyers and economists, what we could do with such a network of cases?
Well, for me, this is pretty clear. With such a network of decisions and cases, we can gain a clearer and more detailed understanding of concepts we may not fully grasp otherwise, because they have been put there out of everyday language, out of our everyday experience. Now, by analyzing these decisions and clustering them, we can understand, we can improve our understanding of these concepts. And, for example, by improving our understanding of plausibility, we can apply it more effectively in practice, making it easier to differentiate what is plausible from what is not.
Okay, let's take that a step further in a sense. You do say that using AI, and you give more details in the paper, but let's take it to the abstract now. You could also identify parameters that influenced decisions, whether it is to assist in identifying the factors that the judges and the agencies knowingly considered, right? Or ultimately maybe also to spot inconsistencies in the court rulings. Now, I could see how, as a practicing lawyers, you may want to engage in such an endeavor to indeed try to challenge the agencies or judges when it comes to their own case law. Now, I guess my question is a bit unfair because you are an academic, but are you aware of practicing lawyers doing that? And regardless of whether or not you are aware of them doing that, if you were to practice, would you indeed use AI in such a way?
Yeah, I definitely would do that because consistency is essential. It is, protecting consistency over time is needed to guarantee the rule of law. So consistency is worthwhile, and courts and authorities must treat similar situations alike and different situations distinctly, and they should be held accountable for that. So if I were a practitioner, I would definitely use AI to have an idea of these vague and indeterminate concepts to try to find out if there is a fil rouge, if there is a common sense, a common meaning for these words, and then try to ask judges to be consistent in giving meaning to those words.
Yeah. And or to rely on past consistency and saying in the past, when it comes to that concept that is a bit vague, that's the way you read it. And it happens that it's very good for my clients, therefore please do so, right? Could you give a couple examples of those concepts that will be considered to be vague? Because, we are in the space for so long that even the concept of relevant market I find to be absolutely very clear now, although maybe in practice it's not so clear. So do you have a couple examples in mind?
Well, let's use the one that you gave me, the concept of relevant market. Well, I may agree that the concept of relevant market may be perceived as vague, but actually we have developed over the years an heuristic, a process to get information, to collect data, to keep on to be capable of concluding whether somebody is a rival or somebody else, and how many rivals or how many competitors are within a relevant market. So still, you may say that the definition of the relevant market is not the most precise definition ever, is not a mathematical definition, okay, but still we know how to build up a definition in practical cases, the finding of a relevant market, and how to discuss about it. The problem with plausibility instead is that we have never devoted time to this concept. We have never tried to understand what's the difference between plausible, possible, or probable, for example. There are judges that have tried to do that, have tried to talk about speculations and things like that. So this is the problem when it comes to natural language, that the definition of the relevant market is a technical one. Maybe it is vague for those who are not antitrust practitioners and academics, but still, within our community, it is very clear. When it comes to words coming out of our everyday language instead, each of us may have a different understanding of what plausible means. And this is because each of us has different backgrounds and maybe have never spent time on working on these definitions. And so the idea of asking people to focus on these words, especially when they play a key role in defining standard of proofs, standard of pleadings, or substantive rules, is meaningful for guaranteeing consistency and clarity and accountability when it comes to decisions.
Yeah. So as I already alluded to, so one way of using it is to say, we take a concept, let's say relevant market, and we use AI to find how the concept has been defined. And in fact, I've been asking for the European Commission, I think it will be very easy for them to do, to create a search engine that will actually give you access to cases, relevant cases when entering a few keywords, right? So this will be something I think easy for them to put out and will increase our knowledge of what is relevant market. So that's one way. The other way, though, is to use it to identify factors that are unnoticed, right? Even maybe by judges and agencies themselves. And I guess my question is, if we can indeed use AI to identify those factors in saying, well, look, it was not clear before, but now we know that this has played a very important role in reaching a conclusion. Do you think it will affect the way judges and agencies work? Or I guess to ask that differently, how likely is it that agencies and courts will indeed use AI to prevent, giving different definitions to the same concept?
Well, sincerely, I don't know whether they will be available to do that or not. My point is that anybody, judges included, base their decisions on their preconceptions about the world, about their expectations, about their interpretation of certain behaviors. So if we want to protect the idea that judges are impartial and take decisions on the basis of the evidence preferred, we must help them filtering out their own preconceptions that may stem from common assumptions which are not necessarily true, or that can stem out from values, their own values, the values of judges that do not necessarily align with the values of the political community, of the legislator of that time. So, let me say it again, I don't know whether they will be willing to use this screen, the AI screen, to check their decisions and to check, more importantly, their decision-making processes. But if they did, this would really improve our trust in judges because this would make them very accountable.
Yeah, I guess you could also serve them, and I'm not sure if that is the case in all of the countries, even in the EU. But I know, for instance, in France, the ratio that you have when parties will appeal your decision, and the ratio of decision being overturned by the Court of Appeal is actually something that is very important in you as a judge getting a promotion, right? So you do have an interest in doing it before publishing the decision to ensure consistency with your own cases and maybe with the ones of the Court of Appeals. What we discussed so far is how we can use that in order to better understand the law, so starting from the law. But what you also explore in the paper is how we can use NLP and some of the others computational tools starting from economic science instead of starting from the law. And you do explain that some economic concepts can be converted into a formal set of rules that a computer could analyze to define eventually the plausibility of a given scenario. Could you give us some concrete examples of how this would work? And again, the same question, how likely you think it is that we will see that in the coming months and years?
Well, let's get started first from my algorithm, how I would go on or proceed. Well, let's work on the concept of plausibility. To interpret it in line with economic principles, we should consider something plausible if it makes economic sense, right? Well, we define what makes economic sense based on assumptions about economic agents. For example, the idea that they act in their own self-interest and aim to maximize profits. We can teach these basic principles to AI and let it work with them. We can even relax those assumptions and ask AI to identify optimal behavior under limited rationality instead of perfect rationality. Now, in this way, AI can provide an economic interpretation of what is plausible, meaning consistent with economics, in any specific market scenario. So my very simple idea is let's teach to the AI what we teach to students in Economics 101, in microeconomics. Let's give it these basic principles, and let's see if the AI, by putting in place these principles, recognizes whether a scenario is consistent with economic principles or not. This is what judges try to do when they accept to interpret antitrust law in accordance with economics, and I believe that we can reply it via AI.
Yeah, I'm reminded of the keynote that Susan Athey gave last year in our annual conference, in which she explained, which was new to me, that for her at the time, chief economist of the DOJ Antitrust Division, it was easier and certainly more convincing to use machine learning to reach conclusions than to use econometrics, because in the case of machine learning to reach a conclusion, she had to intervene less than when using econometrics. So in a sense, she gave less opportunities to judges to question a lot of choices when using ML, machine learning, as opposed to econometrics. So certainly it seems that some agencies are doing it. Now, the question is whether courts will eventually do that. But that's the perfect jump to discussing tomorrow. So part 2 of our conversation. I don't want to give the impression that you say in the paper that AI will solve everything and everything will become clear and all the concept will be neatly defined. You do explore some of the limitations of current AI applications. You mentioned the lack of abstract reasoning, the inability to fully handle indeterminate concepts, bias amplifications, and the list goes on. My question is this: what specific advancements in AI would be necessary to overcome those limitations and indeed eventually provide a more robust support for understanding antitrust rules and cases?
Well, let me be clear on this. I'm not an engineer, so I cannot really tell you how AI should improve. My guess is that AI should try to advance in neural network architectures that more closely mimic human cognitive processes. So to allow AI to draw inferences and recognize patterns across different contexts rather than relying solely on pattern matching.
For you, that is the main limitation today, out of all of the limitations that you have identified.
Oh, well, yeah, sure. For to me, this is the most important limitation. But still, there may be other. For example, AI could try to encode and manipulate semantic relationships, which is something that right now it cannot do.
Yeah.
And incorporate mechanism for identifying and mitigating biases in training data, such as fairness-aware algorithms, adversarial training, and so on. So, this is the realm this is not the realm of lawyers and academics, legal academics. This is the realm of engineers, data scientists. But I'm very optimistic. I do believe that they will improve AI, and so in the end, AI will be capable of mimicking our the way in which we develop our reasoning.
Okay, let's see how optimistic you are. So, with the development of computational antitrust, do you think we will gradually, and let's say a couple years, have more information on how likely a claim is to succeed? Because indeed, we will be able to use AI to better understand the meaning and the past cases. Or, so this will be the optimistic view. Or on the contrary, do you think that because each parties and each agency and each court will use its own computational tools to reach the conclusions, especially for the agencies it desires to reach, do you think the emphasis on the differences between past cases and new facts will always be put forward by the tool that the agency or the lawyers have decided to use, which would be the pessimistic view in a sense, because you would solve none of the problems you have identified with computational antitrust?
That's a very interesting question. Well, for sure, I am optimistic about this. Well, practitioners might focus on small details to differentiate their cases, and so to argue that the notion of plausibility so far developed cannot be applied to their own cases, specific case under scrutiny. Yeah. But that's where human intelligence comes into play to evaluate how significant those differences really are. I mean, every human being can distinguish between opportunistic behavior and real differences between scenarios, opportunistic differences and real differences. So I guess that to prevent the pessimistic view from taking room, we should still rely on human intelligence and our assessment capacity.
Yeah, that reminds me of a short piece that I read recently from Dario Amodei, who is the CEO of Anthropic. He talks about marginal returns to intelligence. So the fact that AI will indeed increase human intelligence instead of maybe, being a different force and separate from human intelligence.
What you said is really important because the bottom line suggestion behind my paper is let's use AI to make this kind of analysis, which can take time, which may be difficult, which expose us to many mistakes. And let's use our intelligence to make educated guesses about evaluations and assessments, instead of wasting time going through many decisions.
Yeah, at least we can reach faster the point where human intelligence is necessary. Okay, let me ask a final question, and I may have a bonus question, but the final serious question is this, and it's really hard. I know that. We see that competition policy is shifting toward more populism and certainly industrial policy. This is even in the letter that von der Leyen sent the new EU Commissioner for Competition. Don't you think that this casts doubt on whether current method of applying antitrust will remain relevant? And I guess a different way of putting it, which is a bit of a meta question, is whether the plausibility of current cases being useful at all could decrease. If so, because we will take antitrust in a direction that is so different than the one we've witnessed so far, that relying on the past will become, maybe a nice feature, but not very informative. So what's your take on that?
Dear Thibault, you might have a point. If we shift our focus from applying antitrust law to developing industrial policies, importance of precedents could diminish and almost vanish. However, this is precisely why I oppose the populist approach. It's not about resisting change. Antitrust law has always evolved by recognizing the significant differences among various industries, various market situations, various periods of time. What I take issue with is the opportunistic approach where any policy goal, like, privacy protection, environmental concerns, that does not generally relate to market operations, ends up using antitrust rules just because they are readily available, just because they are there and they can be easily applied and they entail very high sanctions. But that's a whole different conversations. If we will switch to a world where there is no antitrust law, but there is also always industrial policy and the attempt to use antitrust law for the sake of human beings, that at that point, all our discussions, doctrinal discussions about the concepts we use, the rules we use, will vanish. And we will be, at disposal of those who are in power of setting the goals and setting the policies.
Okay, but so you said you are optimistic, so you think this won't happen?
No, I think this won't happen. I first of all, I hope so, and then no, I don't. I think this won't happen because this would be counterproductive at a certain point. People will understand that there will be no order at all, no rule of law at all. We need rules and boundaries among the different, fields of law that can be applied here and there. Otherwise, let me say it clearly, we are at the disposal of those who are in power.
Yeah. All right. Let me conclude on a lighter note. Could you give us one movie and one music album to listen to?
Oh, right now.
Right now, on the spot.
On the spot. In Italy we double movies. So I don't know the US or the English title of movies. Okay, let me tell you what I like. As a song, I would go for one of U2, which is a song of 1990 or 1991, I don't remember well, which is a very romantic song. I was 13 at the time, so I'm very affectionate to it. And that was the first song I learned the words by heart. So, yeah, I remember them. So I would suggest that song. One. Well, maybe because why is it important? Well, maybe because you have to follow your goals, your values, and maybe you may have just one, which is a priority over the others. And the movies, well, Joker, the first movie, not the second one, the second episode, the first one. Because I really love the interpretation of the main actor.
Yeah, Joaquin Phoenix. What about the second one? Have you seen it? I'm told it's not that good.
Not yet. I read some comments on it, and they are not very enthusiastic because in the end, the character looks like an ordinary human being, just crazy one, instead of that kind of hero, negative hero that discloses the problems and the contradictions of our society.
Yeah. All right. In the spirit of the season and not to escape the question, I will recommend that people watch Beetlejuice. The first one is a classic. The second one is as good as the first. It's a Tim Burton movie. So have a look at that. On that, Mariateresa, thank you so very much. I hope to see you soon in person, maybe in Italy, because the weather will be more lenient than it is here. And thanks so much for writing such a great piece. And to everyone out there, I hope to see you soon as well. Take care of yourself. And if you can, someone else too. Bye-bye.
Bye-bye, everybody.